All right, let's bring it back. We don't want to wait any longer for our next presenter, Dave Riewald, freshly back from a successful set of engagements in the Catskills. Dave, take it away.
Well, thank you for that introduction, but I am not Dave Riewald. I know I look like him a little bit and I sound like him a little bit, but I am not Dave Riewald. My name is Fred McNasty. I represent the employees that sue employers and supervisors. I sue the companies that Riewald and that Bullard law firm defend all the time. I was walking down the hall out there a little while ago, and I ran into that Riewald guy. He and I have cases against each other all the time, so we know each other. He told me he had this emergency court hearing. He just got a call from the judge, and he had to scoot on out of here and go to the court hearing. He gave me his PowerPoint slides and the clicker and said, "Would you do the speech for me?" So he ran off to the court, so here I am. Riewald was going to give you his top 10 tips on how to avoid getting sued by employees when you discipline and fire them. But since I'm replacing him and since I'm an employee side lawyer, I'm going to give you a list of 10 things that you should do to ensure that you do get sued by your employees. Dave's list was based on his 30-plus years of defending employers in lawsuits. My list is based on my 30-plus years of representing employees in those same lawsuits. So here's my list. Tip number 1, when firing or otherwise disciplining your employees, do it in a way that causes them as much embarrassment and loss of dignity as possible. You know, many of the employees that come to see me and ask me to represent them, they say they might not have even ever come to see me in the first place over just being fired, but it was the way that they were fired. It was how they were fired that got them so mad. It was the needless infliction of emotional distress on them in the firing process that caused them to be motivated to come see me. Here's 3 examples of 3 recent cases here in the Pacific Northwest where I represented the employees in the cases. The first is the Arrojo versus General Electric case. Now, Arrojo's supervisors decided that they wanted to fire him for poor job performance. They knew that Arrojo was about to head off on vacation with his family and fly out at PDX. So they got in the car, the supervisors did, and they drove to the airport. They caught up with Arrojo in the hallway before the Arrojo and his family went through security. They pulled Arrojo into the restaurant there, and they fired him there while his family waited out in the hallway. And then they tried to forcibly take his laptop away from him. Well, Arrojo came to see me. We filed a lawsuit. And we sued. We claimed every conceivable legal theory possible against the company, including intentional infliction of emotional distress. Well, I'm sorry to say the employer eventually won that case, but only after the case went all the way up to the Ninth Circuit Court of Appeals and after I forced General Electric to spend hundreds of thousands of dollars on attorney fees to win the case. Second example I want to give you is the Campbell versus grocery store case. This is what I call your kids will be left without a mother case. Campbell was a cashier in a grocery store in Springfield. Campbell's supervisor believed that she'd taken $800 out of her cash register till. So the supervisor took Campbell into the store manager's office to interview her. Campbell denied stealing any money. So the supervisor then blocked the exit to the small room that they were in to keep her from going out. And the supervisor then said he would, quote, kick her ass if her attitude didn't change. Supervisor also said, and if you ask Campbell to see proof of the theft that I'm accusing you of, you'll be taken immediately to jail, and because you're a single mother, your kids will be left without a mother. Campbell signed a confession. She was fired the next day. Campbell came to see me, and we filed a lawsuit claiming every conceivable theory we could, including false imprisonment and intentional infliction of emotional distress. Grocery store moved for summary judgment. That's a request to have the case thrown out before a trial. The court denied that motion and let the case go forward to trial. And what the court said in its opinion, I'm happy to report, is that it was letting the case go forward because the supervisor, quote, browbeat Campbell based on scant evidence of any theft by her. That case then settled, and I'll show you my car out in the parking lot that I bought with the settlement money. Third example I'll give you is what I call the walk of shame case. It's Patton versus Target. Target has a distribution center down in Albany, just south of Salem. Patton worked in that distribution center. He was also in the National Guard. Patton went off on a 2-week National Guard training session. When he came back from his 2-week leave for the National Guard training, he was fired shortly after he returned. But it was the way he was fired. After he was told about his firing, Patton was escorted out of the building on a circuitous route that forced him to walk past his former coworkers and friends. Patton came to see me, Fred McNasty. We sued for violation of USERRA, the Uniform Services Employment and Reemployment Rights Act. We claimed that Patton was fired in retaliation for going off on his National Guard leave. That case went to trial here in Portland, and I'm happy to report to you that a jury awarded Patton and I $985,000, including $900,000 in punitive damages, punishment damages, that no doubt were motivated by the fact that the jury was upset about the way he was fired. I used that settlement to put my kids through college. So the bottom line is, how you discipline and fire an employee is just as important as why you fire them when it comes to fostering lawsuits. So please make sure that you do the things that embarrass and shame your employees so that I can file lawsuits against your company. Tip number 2. Make sure your supervisors do not document significant events that occur in the workplace. The documentation of workplace events by supervisors helps employers win lawsuits. So don't do it. I say, just say no. Remember that? Just say no. You remember in the O.J. Simpson trial where the phrase was, if the glove doesn't fit, you must acquit? My phrase is, if you fail to document, I will cause you much torment. So when a supervisor does not document important events in the life of an employee that lead up to discipline, let's call my client Sally, that lead up to discipline of my client Sally, it allows me to have lots of fun in the deposition of the supervisor. For example, I say, Mr. Supervisor, you would agree that it's important to document significant events in the workplace, wouldn't you? Yes, I would. And you were even told by HR that you needed to document events in the workplace. Isn't that right? Yeah, I was. Now, you fired my client Sally for doing X, Y, and Z. Is that right? Yes. But you didn't document X and Y, did you? No, I didn't. So X and Y must not have been important, significant events. Isn't that true? I love that. That's a lot of fun. Add to that the fact that many jurors who sit on employment cases, they believe that if an event was not documented, it didn't happen. So put all that together and it's good for my cases. Let me tell you about a case that Riewald and I handled on opposite sides. Sally, my client was Sally. She worked in a hotel gift shop. Riewald represented that hotel. Sally worked in the hotel gift shop for 2 years. Supervisor Sally claimed that Sally was not a good employee during the entire 2 years, that he merely tolerated her job performance problems and her bad attitude. But there wasn't a single written warning or negative discipline in her performance file prior to October. In October, Sally made complaints about a safety issue. Sally, who worked in the hotel gift shop, complained about an unsafe condition that she believed existed. She believed that the shoe shine product that was being used in the shoe shine stand right outside her hotel gift shop was unsafe and was causing her headaches. She complained to her supervisor. Supervisor did basically nothing about it, basically took a whatever attitude and ignored her. Well, the employer, the hotel, claimed that Sally was so upset and dissatisfied with her supervisor's response that Sally's attitude went in the toilet, her performance soured, and it started this downward spiral of bad attitude followed by written warnings followed by bad attitude. And so, during a 3-week time period in October, Sally got 10 written warnings for bad attitude, insubordination, performance problems. She was then fired after the 10th warning. Sally came to me. I filed a lawsuit. We claimed that she was actually fired. The real reason why she was fired was retaliation for her making a safety complaint. What was Sally's evidence? That before she made the safety complaint, she'd worked there 2 years and didn't have a single negative thing in her personnel file. And after she was fired, she had 10 written warnings in the space of 3 weeks. Obviously, it was because the supervisor was upset about the safety complaint. That case settled, and I bought a boat with that case. So, tip number 2, please make sure your supervisors do not document significant events that occur in the workplace. My tip for you, number 3, when you do document the quality of an employee's job performance on a performance evaluation, please make sure that you pull your punches and give the employee better scores than she really deserves. In other words, don't worry about doing accurate performance evaluations. It's human nature to avoid confrontation and tension in the workplace. So just give in to that weakness. Then when you fire Sally because her job performance was poor, when I take the deposition as Sally's supervisor, I can pull out this performance evaluation and I can have lots of fun. Here's the questions I would ask the supervisor. Now, Mr. Supervisor, you fired Sally because her job performance was bad. Isn't that right? Yes. Well, Mr. Supervisor, if Sally's job performance was bad enough to fire her, why did you give her satisfactory ratings on the last 3 performance reviews? I love those questions. That's a lot of fun. I love to see the supervisors squirm in their chairs when I'm asking those questions. And juries love it too, because jurors, just like you all who sit on juries, every one of those jurors thinks that if their job performance was bad, they would want to be notified that it was bad so they'd have a chance to fix it. Here's a recent Ninth Circuit case that shows what can happen when an employee's performance evaluation scores contradict or are inconsistent with the reason the employer gives for why it fired the employee. It's the Bagley case, and I heard that Yelnowski lady was talking about it just a minute ago. Basically, she talked about a different aspect of the case. Here's what I want you to know about the case. It's this. In Bagley, the employer needed to do a mass layoff of 300 employees, and it had to find a way to pick those 300 employees. It picked Bagley to be laid off based on Bagley's poor job performance. Well, Bagley thought the real reason was because shortly before the layoff was announced, Bagley had made a race discrimination complaint. Bagley thought he was being fired in retaliation for his race discrimination complaint. So Bagley filed a lawsuit. The employer tried to have the case thrown out. The trial court did throw it out, and then Bagley's lawyer appealed it up to the Ninth Circuit Court of Appeals, and the Ninth Circuit reversed and reinstated the case. And in its opinion, what it said is that a big reason why the case was reinstated was because although the employer said Bagley's poor job performance was a factor in why he was selected, Bagley had received, quote, excellent evaluations from his supervisors and had been told he had a future with the company, in writing in the performance reviews. Now, sometimes I get a case with an employee who doesn't have any performance evaluations at all in their file during their employment. So what I like to do in that situation is I pull out the employee handbook that almost always says we will do performance evaluations on employees, and I put that in front of the supervisor and said, that says you'll do evaluations, right? Yes. Well, how was Sally to know that her performance was good if you didn't give her any performance evaluations? Well, I told her orally. Sally says you didn't. What proof do you have? And then it's supervisor's word against Sally's word. So juries eat that stuff up. Juries believe, again, all employees are entitled to be warned if they have a performance problem so they have a chance to fix it. And many jurors believe if it's not in writing, it didn't happen. So my tip number 3 for you is make sure you pull your punches when you do performance evaluations and don't accurately record your employees' performance shortcomings. All right, tip number 4. Hopefully I'm helping you all so far. Tip number 4. Make lots of exceptions to your policies and rules so that you don't apply them consistently. When the Sallys of the world come in my office and want me to represent them, here's a fact situation that I just love to have them tell me about. Your company has a written policy or rule. Let's say it's the no-call, no-show rule, that if some employee is a no-call, no-show 3 times in a year, they're going to be fired. Well, the company made an exception for Bob, employee Bob. Everybody likes Bob. Bob's a good guy, and Bob's an important employee to the company because he's one of the top salespeople for the company. So when Bob violated the no-call, no-show rule, the company made an exception for Bob. 3 months later, my client Sally did the same thing Bob did, but no exception was made for Sally, and Sally was fired. Bob's a 30-year-old male with no disabilities. Sally's a 55-year-old female with PTSD disability who recently complained about not getting overtime pay. Sally's going to claim that the reason why you didn't make an exception for Sally, but you did for Bob, is because she fits in all of those protected classes. So here's McNasty's rule. Write this down. McNasty's rule. Once you make an exception for one employee, you have to justify why you didn't make an exception for the next employee, and the next employee may be in numerous protected, legally protected classes. That's number 4. Number 5. When you fire an employee, don't tell her why. Tell her she's an at-will employee, and therefore you don't have to have a reason by law, and therefore you're not going to tell her the reason. There's 2 reasons why I love it when that happens. Number 1 is what I call the vacuum principle, and it is this. When you don't tell an employee why they're being fired, you have left an information vacuum in their head. The employee is going to fill that vacuum with a reason that fits their self-image. The employee's self-image is not that there's anything wrong with them, it's wrong with you. And so the reason the employee comes up with it for why they were fired, because you didn't tell them why, is going to be a reason you don't like. For example, if it's Sally, Sally's going to flash back on a complaint she made maybe 3 weeks ago. I didn't get a break one day. Maybe I was fired in retaliation for complaining about not getting a break. Or I complained about not getting overtime pay last month. Maybe that was the reason. Or I told the company recently I have a disability. Maybe that was the reason. It's the failure to tell employees why they're being disciplined, why they're being fired, that drives them to come see me, their favorite lawyer, Fred McNasty. So, employees will fill the vacuum in a way you don't like. A second reason why I love it when employers don't tell employees why they're being disciplined is what is jury sympathy. If you ever get so far as having to defend your firing or your discipline decision in court in front of a jury, jurors believe you do have to have a reason. Jurors don't care what the law says. Jurors care about fairness. And if you have not given a reason to Sally, they're going to say to themselves, I'd sure want a reason if I was fired, and they'll hold it against you. So, our tip number 5 then is, so when you fire Sally, don't tell her the reasons why she's being fired. Here's a corollary to that rule. If you do tell Sally why she's being fired, be sure to use lots of vague phrases. For example, here's a couple I love. We're moving in a different direction. Or you have a bad attitude. Or here's my absolute favorite. You're just not a good fit. Those phrases are so vague that I, Fred McNasty, can spin those phrases to Sally's advantage. For example, the not a good fit excuse. I can argue that the reason why you think Sally's not a good fit is because she recently complained about not getting overtime pay or not getting breaks. Or if you say she's got a bad attitude, I can spin that and say, well, the reason why you think Sally has a bad attitude is because she filed a workers' comp claim a month ago. So vague phrases, I love them. Please continue to use them in your firing decisions. Number 6. Please don't worry about timing of Sally's discipline in relation to other events. Timing is the most common piece of evidence that I use in lawsuits on behalf of the Sallys of the world. And what I mean by that is discipline of Sally followed closely on the heels of some protected activity by Sally, such as filing a workers' comp claim. I talked to Riewald, I had a minute with him out in the hall. He told me about this phone call he got from a client the other day. The client wanted to fire their Sally because of a long history of poor job performance. But the employer also told Riewald that, well, just a week ago, Sally said she injured her knee at work and she was going to file a workers' comp claim. So the employer would say that the reason why Sally's being fired is her poor job performance. And Riewald would believe that. But Sally will say that the real reason is because she told the company about her knee disability and that a workers' comp claim was coming their way. So what Sally will point to, and what I will point to on Sally's behalf in terms of timing, is this. She was fired right after she engaged in protected activity. And the other thing is, if the employer says, yeah, but she had poor job performance for years, timing again hurts the employer, because I will say, yeah, her performance was bad for years, but you didn't fire her until after she said she had a knee disability and she was filing a workers' comp claim. So don't worry about the timing of your discipline of an employee in relation to other events. The Oregon Court of Appeals decided this Lacasse case just a few months ago, and I think that Yelnowski lady was talking about it a few minutes ago. I'm going to talk about a different aspect of it. In that case, Lacasse told his supervisor that he had helped another employee in the workplace find a lawyer to process a sex harassment complaint against the company. 12 days after that, Lacasse was fired for poor job performance. Lacasse filed a lawsuit claiming that the quote, real reason was retaliation for helping an employee assert their rights to not be sexually harassed. The trial court threw the case out. It got appealed to the Oregon Court of Appeals, and in May, the Court of Appeals reversed and reinstated the case and said there is enough evidence for the jury to get this case and to think about it and decide it. And the biggest piece of evidence that the court cited was timing. Lacasse was fired 12 days after he referred another employee to a sex harassment attorney. So don't worry about timing. I love it when you don't. Number 7. And this is a biggie. Make sure you give different reasons at different times for why Sally was disciplined. Here's the common scenario I get when Sally walks in my office and tells me about her situation. She says, you know, I was fired, and what they told me at the firing meeting was that they were going in a different direction. That was the reason they gave. And then Sally files for unemployment benefits, and you get that form from unemployment, you got to fill it out and you send it in. A lot of employers say, we want Sally to get benefits. We like Sally. We want her to get it. So let's just write on the form that she was laid off. And so reason number 2 given for the firing is a layoff. And the employer may not have an evil motive for that, but still wrote down that it was a layoff. And then Sally files a complaint with BOLI or the EEOC. And you have to file something in writing responding to that as to why Sally was fired. And now you say what the real reason was. You say it was poor job performance. Well, here's the problem. You've given 3 different reasons for why she was fired. First, you told her you were going in a different direction. Then you laid her off. And then the third was poor job performance. The inconsistency or the shifting in your reasons for why you did what you did with Sally will virtually guarantee that Sally's going to file a lawsuit, number 1. And number 2, will virtually guarantee that her lawsuit will get all the way to trial and your lawyer won't be able to get it thrown out. So, if you want to end up paying money to Sally and me, make sure you give different reasons at different times for why Sally was disciplined. All right, number 8. Isn't this fun? Okay, number 8. Whatever you do, do not train your frontline supervisors on labor and employment law issues. Why would you want to train the very people who have the ability to create the most liability for you? So don't train them on harassment so that they don't know what harassment is, so that they don't know what to do when they see harassment taking place. Don't train them on disability law so that they have an ability to identify potentially what a disability is. Don't train them on what the interactive process is. Don't train them on investigations and how to do them. Why would you want to train the people who do investigations on how to do investigations? So it's the absence of training that will allow me, Fred McNasty, to ask some really fun questions during the supervisor's deposition, such as, now, Mr. Supervisor, you've been accused of sex harassment. You understand that, right? Yes. Well, when was the last time you were trained on sex harassment and what you could and couldn't do in the workplace? Well, I don't remember. Oh, you don't remember? Is that what you said? I love that. I love to see them squirm in their seats when that happens. So, do not train your frontline supervisors on labor and employment law issues. Number 9, we got 2 to go. Number 9, fairness. Don't worry about whether or not an impartial person would review the situation you're dealing with and think that your treatment of Sally is unfair. Don't worry about fairness. Now, Riewald, I hear Riewald get up in these meetings and he blathers all the time about how the law doesn't require employers to treat employees fairly. Yeah, okay, that's true. I agree with that. But the Sallys of the world don't know that. The Sallys of the world think that the law does require employers to treat them fairly. And so when they feel they haven't been treated fairly, the Sallys of the world come to see me, Fred McNasty. And once they see me, you're probably going to get sued. So when you're about to fire Sally, don't stop and ask fairness questions like, was Sally given progressive discipline before she was fired? Don't ask questions like, was she ever warned before she was fired that what she was doing was wrong so that she could fix it? I love it when Sally's totally surprised by her firing. I love it when I can put her on the stand and say that. Don't ask questions like, was Sally given an opportunity to explain explain her version of the events before she was fired? Don't ask questions like, does the punishment fit the crime? don't ask those fairness questions. Just keep on lowering the boom on the Sallys of the world. So don't worry about whether or not you're treating employees fairly. Number 10, this is our last one. Has to do with final paychecks. You all may think final paychecks aren't that big of a deal. So here's my tip number 10. When you fire an employee, don't worry about complying with the final paycheck law. Now, Oregon and Washington law, they make it illegal to fail to pay an employee all of the compensation to which they are entitled by the deadline imposed by the state. So, for example, in Oregon, a fired employee has to get all of the compensation they're owed by the next business day. That's in Oregon. In Washington, a fired employee has to get all the compensation they're owed by the end of the current pay period. So, if you're 1 penny short in the final paycheck or you're 1 day late in getting the final paycheck to Sally, you will have liabilities to me. You will be paying my attorney fees. So, the reason employee side lawyers like me love the final paycheck statute is because we're guaranteed of winning at trial on at least one claim. And if we're guaranteed of winning on at least one claim, my attorney fees are going to be paid by you. And so what we do is, those in my field, we tack on other kinds of claims to the final paycheck claim, like discrimination claims and retaliation claims. We may or may not win them, but in the end, you're going to pay all my fees because I'm going to win the final paycheck claim. So please, please don't bother to make sure that you're complying with the final paycheck laws. That's it. I got to go. I just got caught out in the hallway by Riewald. That's my list of 10 things you should do to ensure that you and I and the judge get to spend some quality time together in the coming days. Thank you very much.